Good evening. I will try and finish tonight's lecture by 10 to 7 at the latest to leave time for some discussion. The issues being dealt with in this lecture, rooted in earlier lectures of Gresham, Professor Bogdanor, were identified as an appropriate topic for tonight's lecture by a member of the audience at my invitation. I don't know whether that person is here tonight or not. I added to the issues he or she raised with a question of my own about the growth in numbers of lawyers in the world in general and in the United Kingdom in particular. And it's a question that fits, I think, with the questions that Professor Bogdanor asked about who rules us, the United Kingdom or Europe, the executive or the judges. However, as I began preparation for this lecture, I wondered whether I'd been wise to leave its subject to a member of the audience. But happily, as time passed, I saw that the topics asked of me to be discussed should be addressed in this sort of gathering. And then more recently, I discovered by chance, as with a couple of other of my lectures, a happy coincidence with other events, a coincidence of timing. For example, the issues raised by Professor Bogdanor, human rights, European or homegrown, may well feature in voting choices about the United Kingdom's withdrawal from the European Union, and even the decision about Scotland separating from the United Kingdom. Making these choices wisely may require a bit more understanding of how the UK operates constitutionally than the non-lawyer citizen typically requires and has. Further, by a happy coincidence, there have been two very recent lectures, one by Lord Justice Laws and the other by Lord Sumption, two of the country's greatest authorities on constitutional issues on similar topics to those that we may be discussing, that crystallise some aspects of the present and important public debate. What, in reality, does the educated non-lawyer citizen know of our Constitution? In a sentence, probably, that it is unwritten and has been derived from various sources. She or he may also know that Parliament is in some senses sovereign and can apparently make any law it wants to. But Professor Bogdanor's earlier lectures show that these simple propositions have now to be reviewed. Our Constitution is regularly contrasted with the Constitution of the United States of America. And one thing that can be said about citizen knowledge is that it will never be possible for United Kingdom citizens to achieve an intimacy with our unwritten Constitution of the kind that Americans have with theirs, because it is simply much more difficult to understand something derived from many sources that may be changing unperceived over time than it is to comprehend the United States Constitution that can exist on a single piece of paper. What is clear is that however great or limited may be the United Kingdom citizen's understanding of her or his country's constitution, she or he and the politicians elected have been turning to the law for help or for control in ever more activities. Statistics show as much. The number of solicitors has more than tripled in the last 30 years. The population has grown by nothing like that sort of factor. In the last 5 or so years, the number of barristers at the self-employed bar has been steadily growing by 5% a year. And I've provided some unverified statistics in the footnote to the printed paper that deal with some other countries. I'm not sure what this growth in lawyer numbers reveals about ourselves, but have feared instinctively that it was unlikely to be healthy. And I've wondered whether, by way of giving a broader setting to Professor Bogdanor's issues that we need to explore, whether law was actually becoming or has become a new religion. I was to find my lecture caption above, embodying this notion, perhaps reflected in the thinking of one or two of the legal luminaries whose illuminating lectures I have already referred to and to which we will return. By its ever-increasing role in our lives, has the law become a new religion? Are its practitioners and judges filling priestly and episcopal, or even higher roles, wherever a problem with an ethical or moral component is addressed? Now, I'm afraid I confess to some skepticism about lawyers, not just because I might have preferred to have done something else as a career and found myself spending by default too much time in the company of lawyers. I may simply be an example of the professional person who George Bernard Shaw said inevitably becomes a skeptic concerning his profession. But he said that about those who master their profession, so maybe not me. You and I must therefore be cautious about my skepticism and ask what good reasons there may be for such an increase in lawyers as there has been. There are several, and it's not all been a consequence of the generous increase in legal aid for criminal and civil cases that occurred in the 1970s and 1980s. Let me give you a few examples. First, it was not until 1964 that employment tribunals, now an established part of our legal life, were first created as industrial tribunals. That led to many lawyers specializing in the regulation of working practices. Before that, the courts could and did deal with employment under the general law of contract, but there was nothing like the scope for pursuing employers over unfair dismissal, unequal treatment that has developed since. Few, I think, would say that this development and the associated increase of work for lawyers has been a bad thing. Second, what's called administrative law has expanded enormously. Here is an example of how and why. Some of you in the audience will recall how GCHQ, now discussed daily in the media, used to be a shadowy body known to provide signals intelligence to the British government and armed forces, although before 1983 its existence was not even acknowledged, although it recruited openly graduates. Following a spy scandal in 1983, Margaret Thatcher, the ex officio Minister for the Civil Service, decided that GCHQ employees should not be allowed to join a trade union for national security reasons, and she enforced that decision through an order in council, which is an exercise of the royal prerogative. Despite extensive publicity campaigning by the trade unions, the government refused to reverse its decision, and it offered employees at GCHQ the option of, I think, £1,000 in membership of a civil service association or dismissal. And those who were dismissed had no access to an industrial tribunal to test the legality of what had happened to them. The Council of the Civil Service Union sought judicial review of the decision made by the Prime Minister, conferring with just a limited number of ministers in the way that, for example, had happened, I think, in the decision to authorize the Suez operation in 1956, a special form of decision-making. The judge at first instance, the first trial judge, held that the employees of GCHQ did have a right to consultation, and that the lack of consultation in the process made the decision invalid. A very conservative court of appeal took a, quote, strongly non-interventionist stance, holding that judicial review could not be used to challenge the use of the royal prerogative because the determination of national security issues was an executive function and it would be inappropriate for the courts to intervene. The House of Lords took a different view and came to the conclusion, in overruling the Court of Appeal, that the royal prerogative was subject to judicial review on the basis that it was by default subject to judicial review, or that any prerogative power which impacted a person's private rights or legitimate expectations was amenable to review, or that powers delegated from the monarch in the way that power had been delegated to the Prime Minister as Minister for the Civil Service was subject to judicial review. despite this determination of the rights, the appeal failed on national security grounds, but the case, by exposing what was traditionally not within the court's powers to review, marked a significant change, highly important, and it determined that the application of judicial review would be dependent on the nature of a particular governmental power, not its source. And so although it will still be the case that national security issues are unlikely to be exposed to judicial review, almost all other exercises of the prerogative may be. This case may be seen as the start or part of what one academic has argued has been a slow transformation in the role legal remedies play in ensuring conformity to basic values of democratic constitutionalism. She argues that the process may have started as long ago in 1926, when distrust was felt amongst socialist politicians and intellectual judicial elites about the use of constitutional rhetoric to attack the actions of the trade union strikers. And I provide in the printed note a quotation from Churchill on that topic. The academic also argues, and I think time for a slide, although there aren't going to be very many tonight, but I'll probably still get them wrong, but there it is. This is her summary. She says, well, the emergence of much stronger regional identities in the Celtic fringe, that's one thing. The existence of growing discontent from established political parties, the legacy of 25 years of political division and armed conflict in Northern Ireland, she argues, have all helped to destabilise the existing constitutional order and create a demand for enhanced legal regulation of the exercise of state power. But she suggests that the shift has resulted in a significant expansion in the role of the judiciary in the United Kingdom constitutional system, driven to a considerable extent by the influence of the European Convention on Human Rights and the incorporation of that convention into our own law by the 1998 Human Rights Act. And this brings us to one of the other topics that the member of the audience asked me to deal with, a topic that can excite many or most citizens. Once the court started to require discretionary power, in particular the royal prerogative, to be exercised in conformity with the rule of law, judges even dared to assert authority over some Foreign Office matters. I dealt with that in the note. And there was an example of an asylum seeker case of some importance, where by ministerial regulations, asylum seekers, were denied the right to welfare support. But in the House of Lords, the case was dealt with on the basis that it cannot ever have been conceived of as right to allow regulations to drive individuals, those people deprived of welfare support, into a state of destitution. And so this is another example of how there was a growth in the work that lawyers could do in administrative law cases. Now, of course, there are individual administrative law decisions that may inflame the readers of some newspapers, but generally, I doubt if there would be a majority vote against the law doing most, at least, of what it has done in the administrative law field in recent decades. Now, the convention comes about before and it becomes effective on us before it was incorporated by the 1998 Act. A couple of cases, one of which you're probably some of you will remember. There was the case of McCann and others, where there had been the killing by UK security forces on Gibraltar of 3 people who were expected to be en route to commit a terrorist offence. And they were they were killed. And the matter found its way to the European Court of Justice, which deals with the Convention. Where are we? Here. And the European Court found, so this is quite an early case dealing with that case, it found that in summary, having regard to the decision not to prevent the suspects from travelling into Gibraltar, to the failure of the authorities to make sufficient allowances for the possibility that their intelligence assessments might in some respects at least be erroneous, and to the automatic recourse to lethal force when the soldiers opened fire, the court was not persuaded that the killing of the 3 terrorists constituted the use of force, which was no more than absolutely necessary in the defence of persons from unlawful violence within the meaning of Article 2 of the Convention. So this is an early case. Have I listed the... There we are. The European Convention has many articles and protocols. You'll be familiar probably from the newspaper with many of them being referred to. Article 2, right to life. Article 3, torture. 4, slavery. 5, right to liberty and security. 6, fair trial, and so on. And there's a list there, and you can again see that in the note. But here we see an early example of really quite a significant intervention in and comment on the lawfulness of what was being done by the British government. Less familiar, but at about the same time, was a case of a man called Chahal, who was to be deported to India for his political activity, and he'd been arrested on suspicion of conspiracy to kill the Indian Prime Minister, I think. But he said if he was sent back, this would result in a real risk of torture with inhuman or degrading treatment, which would violate Article 3, prohibition of torture, of the European Convention. And the court found, yes, a violation of Article 3 was established. Article 3 contains in its detailed articulation a guarantee which is absolute in expulsion cases, and the United Kingdom could rely on no explanation, no national security interest to justify the deportation of the applicant. So early cases. Now, I spent some time on administrative law because I'm going to, I hope, connect things up a little bit. And the development of our administrative law under our own unwritten constitution, affected as it has been by the human rights law coming from Europe, may lead us again to glance somewhat enviously at the United States, where the written constitution more readily allows courts, any court I think, to strike down a law as unconstitutional. So you can't do that. And of course, some of us have in mind from news stories, if from no deeper research, how the American Constitution was relied on for social change of great importance. In the third of Professor Bogdanor's lectures, set for my or our reconsideration tonight, Professor Bogdanor shared his platform with an American academic, Cristina Rodriguez. And her lecture, which you can download and read and is extremely interesting, provides a valuable antidote to much of the grass is greener on the other side approach to the use of law. And that lecture provides from an American perspective, 3 really interesting things about how law operates with and within society. The 3 things that she makes interesting for me is this. First, the very fact that that American courts have the power to strike down laws as unconstitutional can lead to the legislature passing laws that it knows will be struck down. And so it becomes somewhat negligent or careless in the way it makes law. Second, and I think very important, the very famous 1953 case of Brown versus the Board of Education, cited by those of liberal persuasion for its role in ending racial segregation, in fact led, when delivered, to such discontent in the voting public that the decision was not acted on for years. And then, only when the Voting Rights Act of 1965 was enacted. Third, that the almost equally famous 1973 case, 20 years later, of Roe and Wade, that struck down a state law prohibiting abortion, led to a backlash from the public, galvanizing a certain segment of the American population and giving them a single issue around which to mobilize in support of the Republican Party. Now, Cristina Rodriguez didn't feel she could go so far as to blame everything that happened in the 1980s and the election of Ronald Reagan onto the case of Roe and Wade, but she does take the view that the court simply intervened in a debate that was going on in the political process, and that the court intervened at too early a stage. She said it was attempting to settle a controversy that the people themselves had not yet resolved, because for her, the American system is one where the courts are in a developing dialogue with the legislature over topics of that kind, discrimination and abortion. Now, that happens in America may actually have some resonance to what is now the position between us and Europe. And that's why I spent some time expanding upon it. And we may be able to take heart, I hope, ultimately, from the American experience. And it's also something that Lord Sumption deals with, as I read it, in his lecture. So that's one significant development area for lawyers. A further area of growth has been in the regulation of professions and of trades. Regulation of banks, lawyers, doctors, nurses, airline pilots, architects has all developed enormously over the last few decades, and some of that regulation needs lawyers. The professional directories of barristers' chambers showed that those chambers that used to advertise exclusively practitioners doing criminal cases will now trumpet about their work in regulation. And if you talk to the barristers, they will explain, they all do, that regulation work is better paid because it's privately financed and a substitute for the less well-paid criminal work they can no longer afford to do. But despite that, there has been a net and significant increase in work for lawyers. Finally, I think in the list of additional work for lawyers, known to many, not least from the advertising that is disagreeable to some, there has been a growth in personal injury litigation. Now, we may all have reservations about the increasing monetization of the natural incidents of life by the compensation culture that employs many lawyers at good rates. Arguments for and against are easy enough to articulate, and we have not yet gone down the route of having a policy that exists in some countries of no-fault compensation. But this is, or rather this has been, a growth area, even though it's the particular scheme of no-win, no-fee litigation where a lawyer for a claimant, could get up to twice his fee if he won the case from the defendant's insurers. That scheme is being scrapped, but nevertheless, in the years that it's been in operation, it has added significantly to lawyers' work. I said that was finally, but I missed a very, very important category of work that lawyers engage in. How often, as you allow John Humphreys on the Today programme to tell you how the world is doing, do you hear of an inquiry being established into this, that, or the other thing? Well, very often. And most inquiries involve lawyers. I would be only too pleased to work on or to preside over an inquiry. But if I did, I might be somewhat concerned that I would be involved in the exercise of power that perhaps should not always be in lawyers' hands, because many inquiries today involve policy decisions, not just legal issues. And if inquiries are now regarded as matters that can properly deal with policy issues, I'm not sure that there's justification for having taken from politicians things that should be theirs to handle in ways answerable to the public they serve. And again, I think I find support in this from Lord Sumption. Now, of course, part of the answer to this is the recurring statement that politicians are terrible or worse than they were years ago, just in the way that police officers get younger. It's one of those things that is always said. It's recurringly said, it's constantly said, and it may be completely untrue. There may have been greater superficial deference to politicians in some earlier decades, but I'm not convinced there was greater trust in them overall. It is inevitable and possibly healthy to question and distrust those whom we elect to rule from time to time, or indeed on a regular basis. Deciding to allow others to run your life, declining or refusing to participate in politics yourself, has the effect, as Plato explained some time ago, of exposing you to the penalty of being governed by your inferiors. Nothing is new. Now, if on detailed analysis there have been far more public inquiries presided over or involving lawyers than there used to be, and if the conclusions of those inquiries are much more policy-directed than they are fact-driven, compare Lord Denning's inquiry into Profumo with Lord Levison's inquiry into the press, totally different kinds of inquiries, then this is the growth in the work of lawyers, but it's outside the area of the law itself. Let's come to Lord Sumption in light of what I've been able to tell you. There's three quotes from him. First of all, he says this: "We live in an age of unbounded confidence in the value and efficacy of law as an engine of social and moral improvement." I'm not really allowed to say hands up, am I? Okay, those who agree with Lord Sumption nod. Oh, last month. That's his view. And I'm not really sure he's right about it, but that's his view. However, the next bit I do agree with, because he sets out in his explanation of what the law does this: we regulate almost every aspect of employment practice and commercial life, at any rate, so far as it impinges upon consumers. We design codes of safety regulation designed to eliminate risk in all of the infinite variety of human activities. New criminal offences appear like mushrooms after every rainstorm. It's been estimated that in the decade from 1997 to 2007, more than 3,000 new criminal or regulatory offences were added to the statute book of the United Kingdom, turning from statute to common law a wide range of acts which a century ago would have been regarded as casual misfortunes or as governed by principles of courtesy, and they're now actionable torts. Rather, what I was saying about the development of law, everything falls for a lawyer's consideration. Now, he considered that the problem is that the technical and intellectual capacities of mankind have grown faster than their moral sensibilities. And the third quotation I'm rather pleased about, because, as you will appreciate, the caption for my lecture was set when I set these lectures, last year. Lord Sumption only spoke last month or something. And he said this: "At the same time, other restraints on the autonomy and self-interest of men, such as religion and social convention, have lost much of their former force, at any rate in the West. The role of social and religious sentiment, which was once so critical in the life of our societies, has been largely taken over by the law." He doesn't express it the same way as I do in my caption, but I think the point is not a million miles away from the one that I have been concerned to make. Let me turn now then to, in a little more detail, to the European Convention, which we were asked to deal with, or I was asked to deal with by a member of the audience. The law comes from the European Court of Human Rights, a product of the Council of Europe that sits in Strasbourg, and from European Union law itself. As you may or may not know, the present state of the law is this: if our law is in conflict with European human rights law, for example. Our courts cannot strike down the European law. They have to respect it. And so what they have to do is they make a declaration of incompatibility. It's a statement. And that then leads to a dialogue between our country and Europe, at the end of which our law, it is hoped, will be changed if it's necessary to do so to become compatible, and that the impasse will be broken in that way. And normally that is indeed what happens. I'm bound to say, as a citizen, that the concept of a declaration of incompatibility is a little harder to understand than a simple proposition, it don't fit with the Constitution, which is what you might say in another country. And there must surely be room for the argument that the best laws and the best legal systems are those that are most easily understood, and that they're the ones that are most likely to gather public support. So what we have in Europe is not ideal, even if it is satisfactory. But nevertheless, that's the broad structure of what has to happen at the moment. Now, Professor Bogdanor's various lectures, 3 were asked or identified for me, operate as a very good point of departure. In his 2005 lecture on human rights, he dealt with a case called A, an antiterrorism case, which had led to the Guardian headline saying, "Judge's verdict on terror laws provokes constitutional crisis." And it had to do with whether non-British citizens could be held indefinitely without charge if the Home Secretary believed them to be a threat to national security. Professor Bogdanor thought that the Act of Parliament concerned had been raced through with indecent and ill-considered haste, and he was concerned about whether this process of negotiation was going to operate at a time when there was an election looming and the government would not be willing to be seen as soft on law and order. In fact, the case did ultimately negotiate itself to a conclusion. But the reason he raised this was to present a point of view to which I will return, his, that human rights law may be really important for unpopular minorities who nevertheless have rights. And he thought, well, the system was less important for majorities and for nice people, more important for people like asylum seekers and terrorists who, despite all of that, actually do have rights. There was another case that came after his first lecture, of the 3 that I am to deal with, the case of Blackstock, where there were reviews of a man who was convicted of wounding a police officer for continued detention. And various of the articles of the convention were relied upon, and the convention found against our country on the basis that the delay in dealing with him of 22 months was unlawful. There was another case in November of 2005 involving a man charged or investigated for sexual assaults with subject to very considerable delay, and again the court held that there had been violation of their articles there. Why do I mention these? For a reason to which we'll come. His next lecture in the next relevant lecture in 2006, called "The Judges and the Constitution," had Professor Bogdanor suggesting that the constitutional jurist Dicey was correct in thinking that the roots of our parliamentary sovereignty lie deep in our own history and in the particular development and peculiar development of our English constitution. And he queried whether judges can or cannot alter this sovereignty unless Parliament itself and perhaps the people by referendum agree. Now, he noted, despite your failure to nod your heads, he noted, I don't know, perhaps it's something, he's not a lawyer, Professor Bogdanor, he's a constitutionalist. But nevertheless, he noted that survey, apparently, evidence showed that people trusted judges more than they trust politicians. And it may be argued that judges, he said, were filling a vacuum, although they were being asked to decide on cases which entrench upon government activity and work. He also said, well, it would be surprising if the law was being trusted with this now when it would not have been trusted with it 100 years ago, because, of course, now our country is much more democratic. Our politicians have women amongst them, and the franchise is universal, and so on and so forth. How strange, he said, that, if it be the case, lawyers are now trusted more when democracy has, at least in its structure, much more satisfactory form. There was a case some of you will remember in September 2006 of Blake, the man who wanted to be able to write his book about being a double agent, and he was delayed in doing that. And for a long period of time, George Blake and the European Court found against us. And then we come to the third lecture, where Christina Rodriguez participated along with Professor Bogdanor. By this stage, things were developing, and it was clear that this process of negotiation, where there's incompatibility, was reasonably satisfactory in our country, because there'd been some 20 cases, and on each occasion, after a bit of a delay, the matter had been sorted out. He repeated his view that the law was of value for unappealing minorities. And when looking at whether judges should decide what happens or politicians, he reminded us of what Supreme Court Justice Jackson, the man who prosecuted Nuremberg, said in 1930s about judges and their decisions. Very funny, unless you're on the receiving end of it. Judges, that's Supreme Court judges, of course, were not final because they were infallible. They were thought to be infallible because they were final. And the point that he was making was, yes, of course, if you have something coming from the lips of a judge, you sort of take it as being right because there's nowhere else you can go with it. But it might not be right. He thought that the human rights laws it was then developing was not wholly adequate to meet the kinds of challenges in our society, although he thought by and large our minority groups didn't really need that much interference or support from Europe. Christina Rodriguez also suggested that, I suppose, that there comes a time when you can't reject statistics altogether. She suggested that approval ratings in America for lawyers are very high, certainly when you compare with Congress, which she said rarely breaks 20%, and a president only breaks 50 to 60% approval rating, and then only when the economy is going well. And she explained in her lecture, or her part of the lecture, that from an American perspective, the equivalent of judicial review, reviewing the work of government, was established early and often reinforced, because the written constitution of America enshrined a structure of government and a set of rights that were supposed to be outside the sovereign will of the legislature. Now, there were then many cases, or several cases, that I set out in summary form in the note. And again, I'll just give you a headline for a reason to which I will come. There was a case called Al-Sqaini, to do with human rights law for England operating in Iraq, where Iraqi civilians had been killed, and where we were found to be non-compliant in the process we were going through. It's a case called Abu Qatada, where deportation to Jordan was banned on torture grounds. There was a case called Abdi, where somebody was unlawfully detained for 2.5 years while waiting for deportation. He'd been jailed for 8 years and other offences and held for 2.5 years after serving his sentence because no carrier, no airline would take him to Somalia. So there was a breach there and he was awarded damages and costs. There was a detention case involving Al Jeddah. Most recently, and the last case I'm going to mention at all, was a case of Chester and, I'm not sure how to pronounce it, Mkhia, I think, which brings us up to date. And this was the right of prisoners to vote or not. We've had a blanket ban in England. There were a couple of cases in Europe, one coming from us and one coming from Spain, where the court had decided that it was wrong to have a blanket ban. You had to have some kind of system that allowed for some perhaps and excluded others. Nothing's yet happened on that because the declaration of incompatibility has been made and we're waiting for resolution of it. Of course, it's not a politically popular topic for any government because I suppose in the same way as governments all know what might be the popular vote on capital punishment that they cannot respect, they know perfectly well what might be the popular vote on prisoner voting rights that they can respect, at least that they can reflect. I've mentioned these cases for this reason. Do any of these cases really excite you? And I mean really. When the Breakfast and the Daily Mail have both left your table and you're back in the garden or on your way to work, are you incensed? Do you write to your MP? Some people do. But overall, and with reflection of a bit of time, are any of them really that serious, that bad? If they represent an attempt by courts and European Union bodies to reach some understanding of where the law is. Even if the result is wrong, or subsequently found to be wrong, is it better to have tried, to have reached a form of enforced consensus by this declaration of incompatibility and by findings being made against us, and to have moved ahead, rather than to have drawn our English stumps and run the risk of becoming the outsider, the nasty man of Europe, as I think was the category, the description used. Now, on this, it's your views that matter, not mine at all, save to the extent that I am a voter with one vote in elections and access to the legislature had I wanted to stand for office. Now, the two speeches of Lord Justice Laws and Lord Sumption, I'll just say a few words about those, and then I shall conclude within the time that I promised. At least I think I will. Their positions on these issues are not at all identical, but Lord Justice Laws, who is in the Court of Appeal, is not in the Supreme Court, but should be. Lord Sumption is in the Supreme Court. Refers to the common law, that's our law's virtues, being what he describes as Catholicity, an ability to draw on law from all sources and slowly to change our law and to develop it. And in a summarized form, what he says is, yes, the law from Europe's great. We should be drawing on it as we did before the convention ever came into being. We were using things from Europe to develop our law. The problem now is, perhaps, that because of the structural way in which it comes in, people are going to be less inclined to accept that it's a good thing than if it was simply brought in by the judges acting as they always did as common law judges. Incidentally, I think both speeches are extremely well written, actually easy to read, and I've given you citations for both of them in the handout paper. But Lord Justice Laws is concerned that controversies of a political nature in Europe will undermine the confidence that we have in those bits of European law that we adopt. He also took the view that this notion of complete sovereignty, Parliament can make or unmake any law, is not actually quite fair, that there are constitutional statutes that are beyond that, like Magna Carta, but also like the European Communities Act, or the Act of Union and the Reform Acts. And so his concern is that law coming from Europe may undermine our confidence in our own legal system. Now, he takes Lord Sumption to task, I think, for relying on a part of the convention which suggests that we have to abide religiously by convention law, drawing to our attention that, in fact, if you read it, we only have to be compliant with convention law when we're actually a party to the proceedings. He makes the point, if the convention law decides something about Article 8 for another country, so what? That doesn't affect us. It's only when we're actually a party to the litigation. And he takes the view that he takes the view that in some cases arising from incompatibility, the debate is not about the weight to be accorded to the convention right on merits, but it's about the respective roles of government and the judiciary. And that's really, I think, the problem that we're all grappling with whenever we hear this on the radio or the television or read about it in the papers. And it's uncomfortable for us, not just because it deals with what may be legal rights, but because the boundary between law and policy is blurred, and there is an encouragement coming from Europe, some would say, for lawyers to get more involved and for the law to get more involved in policy decisions than we're used to, and than perhaps is good for us. Now, Lord Sumption, in a speech, I think, that drew admiration from some in the Conservative Party, took a different view. He explained, first of all, quite an interesting bit of history, that the European Convention on Human Rights reflected the concern of European nations to ensure that the extremes and despotism and persecution characteristics of the German Third Reich would never be repeated, as well as a growing fear of the new totalitarianism coming into being in the Soviet-dominated communist territories. So that, and no doubt he's right about that, and that's actually where it came from, and it's grown since then. And he takes great exception to he takes exception to the notion that European lawyers and convention lawyers have of the convention being what's called a living document. That is to say, you drafted it 40, 50 years ago when you have no idea what other things are going to develop, but when those other things do develop, you say, oh, well, we'll now interpret the law as affecting that. When what you're really saying is, well, we, the judges, are saying that had those drafting the convention in those days had this in mind, this is what they would have decided. A bit perhaps as happens with the American Constitution. And he gives examples in his speech, which is powerful from this point of view, of saying that in fact, far from it being fair to say the convention drafters would have envisaged this and would have done this, absolutely the reverse. There were some things that they specifically ruled against, but that are now things that they would rule for, or vice versa. And he feels that the Human Rights Act involves the transfer of part of an essentially legislative power to another body, and rejects the suggestion that the acts of Parliament that we've had that allow that to happen are in any sense democratic. He expresses favourable views about politicians, you'll be pleased to know, sometimes in a somewhat barbed way, and says that we, the people, expect our politicians to be not just useful but attractive, and that we demand from them transparency and consistency. When we get those things, or rather when we don't get those things, we then turn to the courts of law. Well, now, that's a very rapid summary of detailed and interesting speeches, but I do commend them both to you if you're interested in the subject. And I conclude in this way, because I can hardly quote the views of others or refer to the views of others without at least venturing my own. As suggested already, I reckon that the debate that incompatibility arguments between us and Europe generate may be worth more than all the forms of cost to the country of being subject to European influence. That's why I asked you the question, do you really get excited about these? Are they actually that important in the great scheme of things? I can understand how Professor Bogdanor considers that human rights may be more important for the politically weak, unpopular minorities, but I don't understand how you can have a differential system. You've got to have a system of law that operates for all of us and is understood by all of us and not muddled. I understand Lord Sumption's concerns about the Convention being treated as a living instrument in the way that Strasbourg Court says it is, to allow interpretation of the Convention in light of evolving social conceptions that are common to the democracies of Europe. But his overall conclusion, which you'll find in a footnote in the note, that there may be a risk for societies that allow too much power to pass to law-making courts, is one I would hope to be wrong. I repeat that. He seems in a very elegant, Lord Sumption's a very highly intelligent man, author of books on history, and like Lord Justice Law's, great language. His last paragraph seems to suggest that the path we are going down of affording power to lawyers is one that could lead to decay. Indeed, he likens it to the republican constitutions of Athens or Rome or the Italian city-states of the Renaissance, but I don't think we've got time to go into that. Lord Justice Law's conclusion that applied the mechanism of the common law, the Convention can be and should be a force for good, one that he summarizes in this way. He says it puts more teeth during European law, it puts more teeth into the common law's mouth, and takes the view that the balance between law and government is harboured and matured by the common law's process of continuous self-correction, which allows for refinement of principle over time. And I hope he's right about that. Early to say, but I hope he is. He says, if we keep faith with our law, we will enjoy a noble inheritance and may anticipate a tranquil future. Well, I imagine that's a hope we would all endorse. To be engaged on a journey with our nearest geographical neighbours in which we seek to identify common principles of law for the good of all is unlikely to be a bad thing. Along the way, we may have to live with compromises. For a time, maybe for a long time. But these are not great compromises. They will never be the sort of compromises that the countries in contemplation when the Convention was first created, Nazi Germany or Soviet Russia, might have extracted from us. We are not going to be obliged to make concessions to racism or to arbitrary detention. And the process of dialogue which we are required to engage in when we find ourselves at odds with Europe may be no bad thing in requiring us to look beyond our own cultures for ideas and solutions. We have seen how in a very different setting, dialogue within the country that has a settled constitution, America, has been a necessary and effective way there to bring about very substantial positive reforms that America has achieved. It can, I think, lead us reasonably to look forward to similar long-term benefits being derived from constructive engagement with Europe in the development of human rights law. Questions? So, let's have a rule, shall we? If you've got a question or a comment, try and do it in 2 sentences. Think it through first, and then we get more time. Yes, sir.
Very good. I'm privileged to listen, and thanks very much. Extremely interesting. I hope to pick up the references and the justices you mentioned earlier. This is a very quick one. This is such a big subject. You mentioned Magna Carta. I now introduced Article 9 of the Bill of Rights and Free Speech. I now introduced the ECHR judgment in 2002-3, whereby there was a case of applicant A against the United Kingdom. The judgment went against applicant A, although the justices decided that she was defamed and harmed in a lot of ways. They introduced what you call the Declaration of Incompetence. They also suggested that within the national parliaments...
And your question, sir?
They introduced national parliaments to stop this sort of thing. What's your view on that, please? That's outstanding.
I'm not sure that I can deal with that question. It's very good and quick, but what you're asking in a sentence is what? We should do what? To try and put it in one sentence.
There's a conflict between the ECHR and the national parliament, our parliament in this case, when though you say minorities are affected in ECHR, in fact, innocent people can be defamed by statements made in Parliament, and the only recourse is the ECHR. If the ECHR agrees that there's a declaration of incompetence, and they should introduce national Parliament measures to stop this sort of thing, but the national Parliament do not do this, what's the solution, please?
Thank you very much. Next question? Or comment. I'm not sure. I'll do my best to answer your question, sir, but I'm not sure. Yes, sir.
The main purpose of the Magna Carta was to limit the amount of money, taxation, that the sovereign can collect. In other words, particularly it says the only reason for taxation is...
And your comment or question, sir?
Yes, so that have we totally abandoned the main purpose of the Magna Carta, which was to limit taxation?
I don't think so, no. And I don't think that the European Court has achieved that or sought to achieve that. Gentleman here. I'll come back to your question in a minute if I can.
Sir, you said that there's been a great growth in legislation. And you've talked about the growth in the number of lawyers. Surely, if it is excessive legislation and excessive detail, say in financial legislation, that gives work to lawyers, the people who are giving them work are the legislators, who are politicians, not lawyers.
I think that's a very important point. Because you could say, looking at the fabric of society overall, that politicians are quite keen to hand over what might be dealt with in a different way, either by themselves or by society with less regulation. They want to hand it over to the lawyers, and that actually does lead to the growth of the lawyers, and indeed to the lawyers becoming a form of religion or religious functionaries. It's hard to know, given that probably many countries are doing the same thing, how you could control it. For example, something that many people in this room, I think, are familiar, or some people in this room are familiar with, is regulation, to which I referred, of professions and trades and all sorts of other things. And Lord Sumption deals with it when he looks back over a few decades. Is it better that we should live in a society where there is less regulation and we are more responsible for our acts as against our fellow citizens? Or are we in the stage where we really do need not just to have a 30-mile-an-hour limit and hats on our heads and seatbelts and regulated hours for doctors and so on? Now that is absolutely clearly a political issue. And if you don't like the way that, one of the things that every commentator will say, because they have to, is that if you don't like the way society is developing, you do have a way of dealing with it. That is, you can vote for the party that takes the view you want, or you can stand for Parliament and try and advance the point yourself. And that's, of course, why those who might be against lawyers having as much power as they have would say, as Lord Sumption certainly does, trust the politicians. And indeed, and actually Lord Sumption's quite interesting on this. He says, he writes all the politicians down and says, look at all these ghastly things they do. Who would find any favour in that? He said, well, I would. because he said it's having people who fudge and mess things up sometimes and don't get things very clear. It's having people like that that ultimately brings you to a society compromise. Whereas if you hand the problem over to a lawyer with a yes/no answer, you don't actually work your way through to the compromise that, for example, happened in the discrimination cases in America.
As a law student myself, I was just very interested by the title of the lecture. Do you have anything to say about the jurisprudential notions of law as a religion?
No, I think I was more inclined to think of the lawyers as practitioners of a religion. But I think that law as a religion perhaps builds on the last question. Law, if it expands and expands to control the way we behave in every particular, as Lord Sumption said, it takes over in being the moral compass from religions. It takes over all other aspects of social control and behavior from other bodies that used to deal with it. So to that extent, I think the law is at risk of becoming a religion. 2 more questions, and then I'll come back to the gentleman here because I haven't answered him yet.
I like the gentleman behind the law student as well. I'd just like to go back to the fact that you said this kind of new paradigm has to be achieved with some compromise, and there are some compromises which we want to come to. What would your comments be as regards the Gibraltar and the Spain dispute at present? Because that seems to be a big compromise which neither the law nor the politicians seem to be.
No, I don't think I actually have a view on that, because I would have thought that would be preeminently a political issue, really. Even if there are legal... No, I'm not sure, actually. No, I don't know. I don't have an answer to that question. What do you think?
That's an example of a compromise which won't be able to resolve by kind of one channel or the other. It has to be... It's going to be born of this new compromise, well, this new paradigm, if you know what I mean.
Yes. I mean, yeah, no, I don't think I have an answer to that question. Sorry. Last question.
Thank you. Is most of the regulation, is it not right, couldn't one suggest it anyway, that it's due to the failure of law to step up to find resolutions to injustice? So it's often where there's been injustice but no resolution through law, often for small claimants, for example. And so regulation is created to institutionalise a way of dealing with things where the claimant had no redress previously.
Yes, I agree.
So it's because the law has failed to step up.
Yes, I mean, well, can you give a precise example within regulation where that's happened? Some of my colleagues on the right who are experienced in regulation may be able to do so. But and I should know from my experience in regulation, yes, I mean, we've been looking at... Yes, the law gave no redress, for example, to the person who was being represented by an unsuitably qualified professional of one kind or another. And then regulation steps in and brings in regimes whereby people have to be able to show themselves to be better trained, qualified and regulated. Is that an example of the solution that you're thinking about?
Regulations around pensions mis-selling. The average small claimant couldn't find redress, it would have cost a lot of money to do so. But in the US, such things might be handled by class actions. We haven't sort of like to do that, but it's left the small man without redress. So in widespread injustice, in the absence of redress, has provoked regulation, and then the lawyers get involved anyway. But it's because they didn't step up in the first place.
Yeah. Right, sorry, we're out of time. Now, sir, I haven't answered your question, partly because I didn't understand it, my fault, not yours. Can you just express it once more and I'll see if I can answer it? No, I can't, somebody else will.
Do the best I can. I'm not a public speaker.
Don't worry, you did very well.
Articles 39 and 40 of Magna Carta introduced, I'm sure you know better than I.
Yeah.
Article 9 of the Bill of Rights of 1689 gives them unparalleled rights to parliamentarians. They can defame innocent people willy-nilly. There's been cases in the European Court.
Right, now I think I'm with
2002. There was a declaration of incompetence there. They also said that national parliaments should introduce in their procedures to stop that sort of thing happening. They've not done so, it's just ongoing. And there's no solution to this in any way. Can you comment on that?
Well,
bear in mind
yeah.
the conflict between parliamentary sovereignty and the rule of law.
I think there probably should be some resolution of that, and it will not find favour with any political party and, for the time being. But these things, you know, they do have a way of working themselves out in due course. And it is the American experience, again, of those two cases. If you move too early ahead of public sentiment, then your efforts to reform will not work. If you leave it too late, then you'll be caught out by the public. The clever thing with really major reform of the way we treat ourselves and behave is for the legislature to get it roughly right. And in the case you're referring to, or the example you're referring to, if there will come a time, or there may come a time, when the parliaments will recognise that the public will is against them, and they will reform. But until then, they may not. Afraid I have to go. Nothing from me until... Thank you.